This video will provide critical information on how to protect your company brand or logo and save you not only thousands of dollars, but untold aggravation and even the loss of your business. This is Charles Mosser speaking. So you could put my comments in context. I've been a business lawyer for over 36 years and the founder of the Mastercraft Law Firm, which has 8 offices throughout Texas. This module is all about how to legally protect your brand and logo, which is critical to the success of your business. I've represented hundreds of businesses in almost all industries where the clients have come to me with issues relating to the protection of their brand. The best case scenario is when the client, let's say a restaurant, come to me in advance with questions on how to protect or register their name. I love these cases because the client can get right to it correctly from the beginning. Unfortunately, there are numerous instances where things have already gone bad, and I mean really bad. In these situations, the client has already been hit with a cease and desist letter or worse, sued. We are then in a defensive position and options are oftentimes limited. As I do in these broadcasts, I will distill everything down to 3 angles of a simple triangle, which I call how to protect your brand. The apex of the triangle is trademark registration, followed by copyright, and finally problematic cases. Let's start with trademark registration. This is the critical step which I recommend that all businesses take before they open, regardless of size. If you get this wrong, your business could easily be shut down. Let me explain with this example. Let's say Joe opens up a new restaurant in Dallas called Joe's Seaside Grill and comes up with a great logo. Moreover, Joe invests tens of thousands of dollars on his branding, which is signage, which features the Joe's Seaside Grill name, menus, decor, the works. He registers his name with the Texas Secretary of State as Joe's Seaside Grill, LLC, and it's approved. Joe also has a great website and has a wonderful grand opening and then success his first year. Everybody loves the place. The locals adore his food, they love his personality, and he gets rave reviews. Everything's going great, at least until he receives a letter from a law firm in New York City with lots of names on it in small print representing another restaurant with an identical name, Joe's Seaside Grill in Manhattan. Now, what does New York have to do with Joe's restaurant in Dallas? Let's find out. The law firm demands that Joe take down his name, cease operations under the name in Texas, destroy his decor and menu, terminate his website, and account for all his revenue during the first year, which they want to have paid to them. Additional, they want attorney's fees. The law firm represents that their client has the trademark for Joe's Seaside Grill, and because of that, they can force Dallas Joe to cease operations. Joe's rejoinder is that his name for the LLC is approved in Texas. Who wins? Unfortunately, Dallas Joe loses because getting an LLC approved is not a trademark. Whoever gets the trademark registered first wins. It's that easy. Since Joe did not check to see if his name was available before he opened his restaurant, he will pay a huge price. Result? There is no defense for Joe and he will go out of business. Moral of the legal story. Always check with a trademark attorney to see if a name for your brand is available. If it is, have your attorney gobble it up. Trademark services are typically inexpensive, and the cost of not securing these IP rights can be devastating. Trademarks apply to your name, a logo which features specific marketing phrases, and the image itself. Easy example would be the Nike trademark, which features the name Nike, which has been trademarked, along with the phrase, just do it, and the Nike swoosh symbol. All have been separately trademarked. Consider the registration of a trademark as a sunk cost of doing business, even if you are unsure whether the venture will be successful. It is easy to avoid this business train wreck with simple planning and counsel. Also keep in mind that if you are presented with a cease and desist letter and lawsuit, the cost of defense could be in the thousands of dollars with a low probability of success. Definitely not a situation you want to be caught up in. The second angle of our triangle is copyright. This is a very simple area of practice and the best way to legally protect the content of your website, marketing materials, videos, photos, and even computer code. Most new businesses will put substantial time into creating unique written and graphic content for their website, Facebook, and other social media. They will also create unique content for marketing materials and videos, which promote the business to the public. More sophisticated clients will create special software for their businesses and hire a programmer to prepare the actual computer code. All of these items can be easily stolen by a competitor, which occurs frequently in my experience as a Texas attorney. Typically, the website is the first item to be ripped off, followed by videos. Without a registered copyright, you cannot make a legal demand for the violator to cease and desist and take down the stolen content. This is unfortunate, as the filing of a copyright is generally an easy process and not expensive. Once registered, federal copyright law will force the infringing party to stop the bad conduct and pay you for any damages caused, including attorney's fees. It's a simple binary situation. You either copyright your material and win, or skip this critical step to your business peril. The third and final angle is reserved for problematic cases. By this, I'm referring to clients who did not follow my advice and probably never knew it was an issue. I run into clients all the time who incorrectly believe that the LLC registration gives them a trademark, which is wrong, or they just didn't think about getting a trademark at all as being something important, and that's also wrong. They typically show up with a cease and desist letter in my office and ask what can be done. In many instances, there's nothing that can be done if the other party has a valid trademark. That's hard to swallow, but the truth. If there is no defense, the goal is to get the client to comply and work out an agreement with the other side for minimal cost. Not always easy to achieve once the violation has occurred. Another angle which works occasionally is to use an exception of the Trademark Act, which carves out a narrow path for companies using a protected mark in a limited geographic area. This is not a slam dunk, and there are limitations on the use of this defense, so you need to consult with an attorney. And it will usually not stop litigation from being filed. Typically, your adversary will challenge this in court, and the result is needless expenditure of legal dollars, sometimes into the thousands. Again, all of this can be avoided by following these simple steps that I am suggesting. The bottom line is to understand these legal branding basics and get a trademark before you open your door for business. And that concludes our module today on protecting your brand. This is Attorney Charles Mosser wishing you prosperity in all things. Thanks for joining me.